So you feel that you can just ignore the court as it stands right now and issue fines from preliminary reviews when the court has said you cannot do that?
Yes.
It's specifically in the court ruling.
Yes.
So you're just ignoring it.
And if that's the way you want to phrase it, those are your
Well, how
words,
should
not
I phrase
mine.
it?
I'm not telling you how to phrase your.
Well, you're the
your-
director. How should I phrase
I'm
that
not
you're
telling you
ignoring
how
a
to
court?
phrase.
Some time ago, I was targeted by the Claremont County Board of Elections to find something to have a violation relating to a campaign finance related item involving me. Remember, I had been exceptionally successful getting candidates tagged for their illegal Larry Householder bribe money, Gene Schmidt and Alan Freeman. Also, David Ubel, the former commissioner who had falsified his petitions and engaged in a fraudulent mailing program. So they wanted to get me, and they referred me for not having completed a finance report timely. I got no fine for that, but I was found to have a violation. Well, I appealed that. They issued that in they call a preliminary review. And when they do a preliminary review, you, the person accused, are not confronted by your accuser. The Claremont County Board of Elections was not present. You don't have the ability to call witnesses. There is no due process. It is un-American. It is completely un-American. But even worse, it's completely contrary to the law. Revised Code Section 119 addresses how these quasi-judicial type government agency bodies have to operate when they do hearings and so forth and when they find fines. And they cannot find fines when they have not allowed the person being accused to subpoena witnesses and to be confronted by their accuser. That's an age-old American concept called due process, but not followed here at the Ohio Election Commission. And today, on October 9th, they're having a meeting. They haven't had a meeting in a while. They're going away at the end of the year. They are doing the same thing, even though there's a court decision pointing out that what they're doing is wrong. It's legally wrong, but even worse, it's morally and ethically wrong. This is not, the king handing out fines. This is supposed to be government of, for, and by the people, not for insiders. So let me run through just some of the key things about the case that I brought. What happens in preliminary reviews is they issue a lot of ticky-tack $50 fines, and probably nobody except me is hard-headed enough to actually appeal that is illegal what they are doing. And I appealed in my case, even when there wasn't a fine, that just tagging me damaged my reputation. So I'm going to take a few points and put on screen a few points from the actual decision. And it says one of the key points is that the determinative issue in this case is whether the commission conducted a full due process 119.07 hearing prior to determining that appellant violated the requirement that an annual campaign finance report be timely filed. That was the core issue. Did I have due process? And within the decision, it hits on key points, such as Section 119.06 provides no adjudication order shall be valid unless an opportunity for a hearing is afforded in accordance with Sections 119.01 to 119.13. So they can't just give you a fine without you even if you get a ticket, you're able to have a hearing if you want to. You can sign your rights away, but you're able to have a hearing. But these guys want to tag people with campaign finance violations and not allow them to have any hearing. Section 119.01E defines a hearing as a public hearing by an agency in compliance with procedural safeguards afforded by Sections 119.01 to 119.113. So that 119.07, it goes on to say, provides that the procedural safeguards, which include the ability to appear in person by the party's attorney, that may present a party's arguments or contentions in writings, and that the hearing of the party may present evidence and examine witnesses. I wanted to examine the Claremont County Board of Elections Director, Stephanie Height, as to my supposed violation. So the judge then goes on and hits on that a lot of the administrative code. So in Ohio, there's the law, and then there's a thing called the administrative code that has weight of law. So a lot of statutes will say that, for example, the commission can define in accordance with the statute's more detailed set of code that has the weight of the law, but is not actually goes through the legislature. So in the decision, it points out things like parts of their administrative code. Another section, 35171-11 subpart E, purports to allow the probable cause hearing to somehow morph into an adjudication whereby a fine cannot be opposed. The rule provides for a probable cause hearing without the formal requirements of an actual due process hearing. For example, one cannot present evidence, arguments, exhibits, examine witness, have counsel present, or the power to compel the attendance of witnesses through a subpoena. What do we call that? America, due process, not corrupt, no due process. And then finally, another section, I'll read it this, subsection E of the rule, that's their rule, purports to eliminate all the due process requirements and allow the commission by fiat to declare a rule violation and impose a fine. Subsection E and this procedure are contrary to law and violate constitutional due process required for administrative hearings. All parties agree 11901 governs the procedure applicable in this case. And then finally, a conclusion that I took out of the decision. Therefore, based on the reasoning set forth herein, this court holds that the commission's order was invalid, contrary to law, and that subsection E of the Administrative Code 35171.11 internally conflicts with the rule itself. It's like drunk people wrote it, and 11901, and is therefore also invalid. So that's the decision. So I came today, I asked Mr. Richter about this before the hearing, even before their meeting even began. And he dodges. Hey, Mr. Richter, how are you doing?
Fine, what's up?
I just got a question for you. So you know that currently there's a court ruling that you can't adjudicate a case and have a fine without having an actual hearing. But it seems like on this agenda you have a shitload of cases that are preliminary reviews where you're recommending a fine.
In the same manner as we normally
So you're just ignoring the court?
No, not really.
And you're ignoring the concept that people are entitled to due process?
They get due process here.
How do they get due process? The court said you can't do what you're doing. You can't issue fines. That's in the court ruling. I know you're appealing it, but it's the law of the land right now until there's an appeal of some sort that would change that.
It's in the process of being appealed.
So you think so you feel that you can just ignore the court as it stands right now and issue fines from preliminary reviews when the court has said you cannot do that?
Yes.
It's specifically in the court ruling.
Yes.
So you're just ignoring it.
And if that's the way you want to phrase it, those are your
Well, how
words,
should I
not mine.
phrase it?
I'm not telling you how to phrase your words.
Well, you're the director. How should I phrase
I'm
that
not
you're
telling you
ignoring
how to phrase.
a court decision that you cannot issue fines in a preliminary review process?
I'm not. You can phrase it however you wish.
I'm not phrasing. That's what the court said.
You can do whatever you wish.
Why didn't you schedule my hearing?
What do you mean?
The court remanded the case for a hearing.
Because it's on appeal.
Okay, and while it's on appeal, you're just going to continue to do the illegal activity that the court said you can't do.
It's not illegal, but we're.
It is illegal. What do you think the court's saying? How do you say the court's, it's not illegal, but the court says you can't do it? So one time when I was here before, when I didn't have a case, you allowed me to address the commission. Can I address the commission today?
I'll leave that up to the chair. I mean, that's the best answer I can give you at this point.
Then when the hearing actually began and they started adjudicating things illegally, he then, I guess his conscience, I guess he has this much conscience left, then he finally informs the board. Apparently he had not even told the board that there was a decision saying that they were acting illegally. And so he informs the board, and then I ask if I can speak. I had asked him if he's in the part where he's going back and forth, I'd asked if I could speak. Notice he never, when you watch this, he never mentions that I had asked to speak. But after he talks to the commission, then I ask to speak, and then they do let me speak. So props to Christina Hagan, the chair, for letting me speak.
Madam Chair, in light of the fact that this is the first violation of this candidate or this person coming before the commission, I would like to find that there was a violation, but without a fine. Okay, very good.
I'll second that.
Okay, very good. motion.
Just to clarify, for good cause.
Correct?
Correct.
Okay, very good. We have a motion and a second. All in favor?
Aye.
Any opposed? Seeing none, that motion passes unanimously. Thank you very much for your time. Okay, very good. Moving on to,
I would like to make, I need to make a statement here before it goes too much further. Mr. Hicks is here. I have not informed any of you of this. As you may or may not recall, a while ago, we acted on a case involving Mr. Hicks for his late filing a campaign finance report. He appealed that decision, and recently that decision was handed down by the Franklin County Common Police Court, essentially indicating that the matter was to be referred back to us for further proceedings, and that the commission should not have acted in the manner in which it did involving Mr. Hicks. We have appealed that decision, and it is on appeal currently. Mr. Hicks is here. He wants to make a big issue of the fact that we should not be acting on any of these matters without further direction, or because of the court decision. Because the court decision is on appeal, I believe we have every ability to go forward and act as we normally would. In my conversations with the Attorney General's office, they believe that the commission's process was not properly interpreted by the judge in the Franklin County Common Police Court case, which is why it's an appeal. And so I'm going forward as if we normally would. The essence of the decision was that someone should have an ability to face their accusers and have due process before the commission. Certainly, I think I have made the recommendations as I normally would. If anybody that is before us, I believe, asks to have a matter set for hearing, we probably, based on the court decision, we should probably go ahead and defer from making a decision in that case and set the matter for hearing.
One thing to notice in what he says people can have a hearing if they want to, but remember, I asked for a hearing and was told I was not allowed to have a hearing.
But aside from that, I believe we're doing better by acting on these matters. People have submitted responses to us. They want to get them resolved in as efficient a manner as possible, I believe. And so, actually for that matter, for the Secretary of State's office, Secretary of State's office staff is here. Presumably all the S cases would have persons. They would essentially be facing their accuser, and so therefore we would have an ability to go forward. But I wanted to address that to the commission before we move forward on any of the cases. I'll be glad to answer any of the questions you may have.
Yeah, just two questions. And I know that it should be important that we stick with our agenda today and not go off of the agenda, but I think that this is an important item to discuss. Two questions about the court proceedings. Is there an injunction or any prohibition from the court as it relates to us proceeding?
No.
And have you, when you talk about conversations with the Attorney General, the AG as our legal counsel, they have they have supported what you've done so far and not indicated from a legal opinion perspective that matter should be ceased at this point?
They have not indicated that we should not proceed forward, correct?
So advice of counsel to proceed and no prohibition from the court from doing so?
Correct.
okay, very good. Are there any other questions or points that any commissioners would like to make at this moment?
I asked Mr. Richter if I could address the commission. It happened once before where he let me. I think you should know the truth of what the decision was.
I think we do have an agenda for the day, but if it's the will of the commission, I would be okay with allowing 5 minutes more or less to just hear that statement. Is that okay for everyone here?
Sure.
Okay, very good. Go ahead, Mr. Rose.
I'll try to be less than 5 minutes. You're all keeping score on whether it's possible for me to be less than 5 minutes. Okay, so I'm going to be very quick. What the court essentially ruled was that it wasn't just that you had to have your accuser there, that anybody against which you were going to assess a fine, the requirement of law, not your administrative code, is that they have not just the accuser present, but have the opportunity to subpoena witnesses, that no fine can be adjudicated per the law without there being a actual hearing where the person, if they chose not to call any witnesses, if, for example, people were informed, if you want to sign a plea deal, basically.
This is hearing room?
Oh,
Yes?
yes.
Okay. Like this one. Like this one. Yes.
All right, we have some guests coming in. Just for my time, when I used to do work with IBM, we had a joke where somebody would walk into a conference room in the middle of a meeting where somebody was talking, and we'd say, "Glad to see that you're here. Please begin. We're ready for your presentation to begin," and made them come to the podium. So I apologize for that. So just to jump back, is that the law requires 11907, statute 119, requires that any adjudicatory body have a actual hearing before issuing any fine. The person needs to know their right to a hearing. The person needs to be able to call witnesses should they choose to do so. Their accuser has to be present for it. So the judge actually ruled that your administrative code was completely contrary to statute, and that what you've been doing for years in preliminary reviews of issuing fines without the person even being aware that they have a right under section 119 of the code to a full hearing where they could call witnesses if they chose and so forth is wrong. So to Mr. Kirshner's questions, I think loaded questions, so I'll leave it at that. You can go look at the case. But to his loaded questions, this is about, you can say, like, was there an injunction? Is there this? This is about due process, something that should be fundamental to all Americans. And when you look at what has happened for years, now that you think about it, I love to see political people admit, you know what? That's a good point. That you can't just find people guilty, give them a fine, without them having any opportunity for their accuser to present the charges and for them to be able to call witnesses, not just appear for a few minutes on there. So that's what the court decision was. Apart from what, I can't believe it's getting appealed. That just is Hicks derangement syndrome, that it's getting appealed. But anybody on this commission should be able to look at it and say, you know what, that's a pretty good point. I raised the point. He said if people asked for a hearing, they could have it. I said to him, I asked for a hearing, if you remember that. And I was told I wasn't allowed to have a hearing. And because these are the $50 ticky-tack fines, nobody's as hard-headed as me to actually in any year have actually appealed it to the court. And so the first person that appeals it, the court says, you can't keep doing that. Now it's getting appealed, but it's a fundamental due process issue. I don't even know why it's being appealed. Of course, the Attorney General is going to say certain things. They're the ones that lost the case to me. So thank you for that. I really appreciate the opportunity, Chair Hagan, to be able to talk. I just think you guys should think about what you're doing, what you've been doing, and that now people need to be on notice before today that maybe they could sign a plea deal and say, I'll waive my right to a hearing and just pay the $50, but that's not happened. That's never happened. And the judge ruled that that is incorrect, improper, and violates section 119 of the code. Thank you.
Great, thank you, we appreciate that.
Was that less than 5 minutes?
You met and exceeded the target, I am impressed. No, but very much thank you for the insight and for that direct feedback, Mr. Hicks. We do appreciate it, and it is insightful.
And then finally, they just proceed. They just proceed and do the same things. And the hell with the due process, the hell with being representatives of the people. They're representatives of the insiders. So what happens is all the little people that get hit with $50 fines and stuff without any due process, they largely just pay them. The people like Alan Freeman, they get hit with $50,000 fines, they just never pay them, okay? And so that's why it's so insider driven, it is so corrupt, it is so wrong. And these people do not believe in basic constitutional principles like due process. How can you be a lawyer and not believe in due process? Phil Richter should not be a lawyer. His management of this has been repulsive. The Election Commission is appealing the decision in the case because they really want to, they're all in before they just go away at the end of the year. They're all in on people should not be allowed to have due process. That's Ohio America, is due process doesn't matter. Even when a judge tells them that what they are doing is wrong, they continue to do the exact same thing.